The Supreme Court just delivered a bombshell that will decide whether your concealed carry permit is a true right or just a useless scrap of paper. The legal ground is shifting fast, and what happens next will shape how 65 million Americans exercise their Second Amendment rights in grocery stores, shopping malls, and restaurants. 5 states have launched an assault on your ability to carry firearms in places that actually matter, and they believe they've found the perfect loophole to make BUREN meaningless. The Supreme Court is about to decide if they're right. If you want to stay on the front lines of this battle, smash that subscribe button right now, because every gun owner in America needs to know what's coming. The legal earthquake that just hit. The Supreme Court has agreed to hear Woolford v. Lopez, and this is a direct challenge to whether the right to carry firearms has any real-world meaning. 3 residents of Maui challenged a Hawaii law that criminalizes carrying a concealed firearm onto any private property open to the public, unless you receive explicit permission from the owner. Every store, restaurant, and mall is presumed off-limits unless someone posts a sign or gives written consent. The Ninth Circuit said it's constitutional. The Second Circuit struck down New York's nearly identical law as unconstitutional. Same legal question, opposite outcomes. Total chaos. When federal courts can't agree on what the Constitution means, the Supreme Court steps in to draw a hard line. That line is about to reshape every Second Amendment case going forward. The coordinated attack on BUREN. After BUREN affirmed the right to carry firearms in public for self-defense, anti-gun states launched a unified counteroffensive. Hawaii, California, Maryland, New Jersey, and New York all passed sensitive places laws designed to gut BUREN. Hawaii's version became known as the Vampire Rule, inspired by folklore that vampires can't enter without an invitation. The state applied that logic to your gun rights. You can't carry on to private property open to the public unless the owner invites you through written permission, verbal approval, or posted signage. Here's the problem. Most business owners never post signs about firearms. Under traditional property rights, that silence meant you were allowed to enter with your firearm. But Hawaii weaponized that silence and flipped it into a default ban. Now, silence means you're banned. No sign means no guns. Licensed carriers face criminal charges for doing what the Supreme Court said they have a constitutional right to do. This wasn't an oversight. It was a calculated plan to make carry rights so inconvenient that gun owners would simply give up. The historical fraud behind the defense. The Ninth Circuit tried to defend Hawaii's law using historical examples, but what they cited shows how weak the argument is. The court pointed to just 2 old laws. The first was a 1771 New Jersey statute banning armed trespassing during hunting season. That had nothing to do with carrying in businesses. The second is even worse. The Ninth Circuit relied on an 1865 Louisiana law passed after the Civil War as part of the Black Code's explicitly racist laws meant to keep freed slaves disarmed and powerless. Using Jim Crow-era oppression to justify modern gun restrictions is morally indefensible. When gun rights advocates asked the full Ninth Circuit to reconsider using a racist black code, the court refused. The Supreme Court made it clear in BUREN that gun laws must align with America's historical tradition, not cherry-picked outliers from unrelated contexts. Hawaii can't meet that standard. What your daily life looks like under this law. Under Hawaii's rule, here's your day as a permit holder. Coffee shop, banned, unless there's a welcome sign. Supermarket, banned. Pharmacy, banned. Restaurant, banned. Every private business is presumed off-limits unless the owner posted a sign or gave personal approval. Most business owners never post signs. They're just trying to run a business and stay out of politics. But Hawaii decided silence equals prohibition. If you carry anyway, you're committing a crime. The Trump administration's Solicitor General called this exactly what it is: a near-total ban on public carry disguised as property rights. The Supreme Court said you have a constitutional right to carry for self-defense. But if you can't carry in stores, malls, restaurants, or any private business, what's left? Your home and the sidewalk? That's not a meaningful right. That's a right that only exists on paper. 65 million Americans in the crosshairs. Hawaii didn't act alone. After BUREN, 5 states with anti-gun legislatures coordinated their response. Hawaii, California, Maryland, New Jersey, and New York all passed similar restrictions. Combined, these states states represent over 65 million Americans, more than 1/5 of the entire population. Millions who got permits, passed background checks, and completed training now can't carry anywhere that matters. State lawmakers made a calculated bet that the Supreme Court wouldn't step in if they technically allowed permits while making them practically useless. Now, all 5 states are watching nervously because if Hawaii loses, their laws fall too. If the court says states can't flip the default rule, then California's law is gone, Maryland's law is gone, New Jersey's law is gone, and New York's law is gone, all struck down by one ruling. This is about whether states can engage in coordinated constitutional resistance, the ripple effect threatening every gun right. This case is bigger than where you can carry. The Supreme Court's reasoning will cascade into every pending Second Amendment challenge, and there are dozens moving through federal courts. States have tested boundaries. Some banned carry in parks and beaches, others barred firearms on public transportation. Several restricted carry in places that serve alcohol. The core question is whether states can use location-based bans to effectively erase the right BUREN recognized. If Hawaii wins, expect a massive expansion of banned locations nationwide. States will declare 90% of public spaces presumptively gun-free. If challengers win, existing restrictions could fall immediately, and states will face real constitutional limits they can't ignore. This isn't just one case, it's a trigger. The dominoes are lined up, and whichever way the Supreme Court rules determines whether they fall for gun rights or state control. The Ninth Circuit's pattern of defiance. The Ninth Circuit had a perfect record before BUREN. 50 challenges to gun laws, 50 rulings upholding restrictions, 50-0. A shutout that shows a systematic refusal to recognize Second Amendment protections. When BUREN changed the legal standard, observers expected adjustment. That didn't happen. The circuit kept ruling against gun rights with the same consistency, wrapping decisions in historical analysis while reaching predetermined outcomes. Judges within the Ninth Circuit have publicly called this out. One judge accused the majority of giving a judicial middle finger to the Supreme Court. The justices aren't just resolving a circuit split, they're correcting a court that refuses to follow constitutional precedent. By taking Woolford, the Supreme Court sends a clear message that open defiance won't be tolerated. The Trump administration enters the fight. The Trump administration stepped in forcefully. The Department of Justice filed an amicus brief calling Hawaii's law a direct threat to constitutional rights. Solicitor General John Sauer argued the Ninth Circuit's ruling directly contradicts BUREN. Hawaii's law functions as a near-complete ban because most businesses never post signs. The brief warned of cascading effects. 5 states have similar restrictions. If Hawaii wins, others will copy the model and carry rights become meaningless nationwide. Administrations usually stay out of state law disputes, but the Trump administration decided that protecting constitutional rights from state nullification demands federal action. They're telling the Supreme Court this is about whether states can collectively undermine federal constitutional precedent. The case that redefines the future. What the Supreme Court decides will echo through Second Amendment litigation for decades. The case answers key questions BUREN left open. Can states presume firearms are banned unless explicitly welcomed? What counts as a legitimate historical analog? Does the right to carry mean you can carry where people actually live their lives? Or can states create so many exceptions that the right becomes meaningless promise? The decision creates binding precedent. Every federal court must follow. Lower court judges sitting on dozens of challenges are waiting for direction. Major gun rights groups filed briefs backing the challengers. Gun control groups and state attorneys general filed briefs defending Hawaii. Oral arguments are set for January, with a decision expected in June or July. Those answers will shape how Americans exercise Second Amendment rights for the next generation, and whether BUREN was a real expansion of freedom or just empty words. The line gets drawn here. The Supreme Court is about to decide whether the right to bear arms means anything beyond ink on parchment. Woolford v. Lopez will determine if your permit gives real protection or if it's just a useless card. This affects 65 million Americans in 5 states, but the precedent reaches every corner of the country. If Hawaii wins, expect a nationwide rush of states copying their model. If challengers win, multiple state laws fall at once and clear constitutional boundaries are set. States won't be able to cross them. We're covering every development from oral arguments to the final ruling. Subscribe so you don't miss updates. Hit that like button if you believe Hawaii's law violates the Second Amendment. Share this with every gun owner you know. And here's our question. If your state passed a law like Hawaii's where you need explicit permission to carry in every store, restaurant, and business, would you even bother keeping your concealed carry permit? Or would the restriction make it pointless? Let us know in the comments. Conclusion: the Supreme Court is about to decide whether your concealed carry permit is real protection or just worthless paper. This affects 65 million Americans now, but the precedent reaches everywhere. If Hawaii wins, states nationwide will ban firearms from nearly all businesses. If challengers win, multiple state laws fall and clear constitutional boundaries are established. Hit that like and subscribe button and help us reach our amazing 10,000 subscriber milestone. Every single subscriber matters. Your support is what makes this journey possible.